Thank you, Richard. All right. So thank you, and it's an honor to be here to speak for the Hayek lecture. So thank you to Professor Richard Salzman for inviting me, and delighted to talk to you today about a subject that I hold very near and dear to my heart, both as a long-standing geek, long before I even went into law, and that is one of the reasons why I do intellectual property law as a lawyer and as a professor, is because this is something that I just find utterly fascinating and enjoy thoroughly. I'm going to start by noting kind of an obvious point, something I don't think is controversial, because intellectual property tends to be controversial. So we'll get to that, and I'm going to just lay down some foundations, and then we can have a fun Q&A. But we live actually in a really amazing world today, right? We enjoy high-tech products like our phones and our laptop computers, and enjoy the benefits of a digital economy. We live and benefit from medical cures that were thought to be pure science fiction just 10 years ago. We can treat cancer. We can treat viruses, the scourge of humanity, for 2,000 years. And all of this stuff has just been brought to us in the past several decades. And several decades ago, that period was amazing compared to the 30 or 40 years that preceded that. Now, at each one of these stages, you can look at what are all of these new incredible products and services that people are enjoying the benefits of in our society. And it's very clear that the sale and distribution of these high-tech products and medical miracles are all brought to us by property rights. More specifically, intellectual property rights. Now, this is a bit of a controversial claim for some, because for some economists, intellectual property is very controversial and actually contrary to innovation and contrary to economic growth. In fact, intellectual property rights surprisingly are controversial among Austrian economists and libertarians, the very people who vibrantly defend the free market. Right? So Murray Rothbard and other contemporary economists and libertarians view intellectual property as government monopolies that interfere with rights of liberty and property and trade. And even Friedrich Hayek was at best ambivalent about IP, and Ludwig von Mises as well, another famous Austrian economist, was also very ambivalent about it. Now, my talk today is going to directly take on that ambivalence, or the controversial views, and explain how intellectual property functions in free markets and how it is a key factor in a flourishing innovation economy. Now, the basic point here is the point that Austrian economists like Hayek and von Mises and others already recognize. Property rights as such drive flourishing free markets and thriving economies. This is true for all property rights, regardless of what type of property right you're talking about. Now, I'm not going to be able to cover every issue in intellectual property. I couldn't do that in an hour or an hour and a half, or even the 40 minutes that I've given myself. So I'm just going to cover two basic points. First, legally, I'm going to just describe why intellectual property is in fact a property right, at least as defined in the United States. That it's not a monopoly interest. It's actually a property interest. It shares very important characteristics that other property rights have, and which have been essential to its success in our economy as such. And that's going to be my second point, that intellectual property, when it's been defined as a property right, as it has been in the United States since the very beginnings of our country, that it is part of a thriving innovation economy, which it has been in our country since the very beginning. Now, why this particular focus in my talk today? Why nature of intellectual property rights is property rights, and why am I going to be talking about how and why they function legally and economically? Well, because it's necessary to establish the basic facts, so then we can then have a productive discussion about how is intellectual property functioning and whether it's functioning properly or not today, and all of the controversies that we hear about today with respect to the smartphone wars and other things. We can't get to that type of discussion if what one constantly hears, as I do when I talk to Austrian economists and go to conferences and engage with my fellow libertarians, that intellectual property is just like taxi cab medallions, that these are just special privileges that are conferred by the government. That is not true. but we need to understand that and establish descriptively. So in other words, this talk is descriptive, or in economic terms, it's a positive analysis, right? Because you need to establish the positive foundation before you can then talk and engage in the normative analysis, which is what I want to get to and which we will get to in the Q&A. All right, so let's start. Now, it is revealing and interesting that, that the criticism sometimes of patents as monopolies is their, claim that, oh, this is a grant from the government, this is like a taxi cab medallion, that, when they say that no one else can drive taxi cabs except for you who have this little special medallion given to you by the local government. Now, it's interesting because there's a kernel of truth in that, and that is that intellectual property started several hundred years ago as special grants of privilege from the crown. In fact, we call patents patents. I don't know if you know this, because the crown, when it would disperse monopoly grants, would do so through a legal device known as a letter patent, which was basically an open letter with the crown seal on it that you would show to people to say, I have the right, and only the right, because King George says I do, to run a market here, or to open a mill here, or to build this bridge. And it was called letters patent because it was law French, and in the French, as you know, the adjective follows the noun, unlike in English. And so later in the 18th century, in good Americans, we said, oh, letters patent. So clearly the adjective is letter and the noun is patent, so we'll call them patents. So that's why actually we call them patents, because they do start with these royal privilege grants. But this historical point and this claim, which is true, proves both too much and too little when you're talking about patents today. It proves too much